business form that existed that would never be liable or responsible for its debts and obligations, who the heck's going to sign a lease with them? Who's going to sign a promissory note with them? Nobody. So does that make sense? It kind of sounds elementary, but it's almost something that I think is important. We'll talk about these distinctions of who was protected and in what context and all these different business forms. But again, no one magic bullet. All right, let's dive into partnerships as a starting point. All right. Could y'all tell I don't like partnerships? Was it obvious?
Very.
Yeah. All right. Can you tell I like LLCs? As professors, I think we have a certain obligation to keep our personal opinions out of things. I keep my political beliefs out of things, but I do not keep my legal opinions out of things. And I have good reason, I think, for why I think partnerships are good and why are not so good, and why I think LLCs are a little bit better. All right. We start at the beginning. Well, let's start at the very beginning. What's the most basic business form in existence?
Sole
Absolutely, sole proprietorship. One person engaging in some type of act for which they seek profit or hoping to be profitable. One man show, one woman show, sole proprietorship. The book talks about those. Obviously, in a sole proprietorship, that sole business owner, that one business owner, is going to be personally liable for all of their own liabilities, their own negligence, their own debts, their own obligations. There is really no business form. Partnerships are just one step up from that. Partners in a partnership, well, RUPA, which is the Florida Revised Uniform Partnership Act in Florida, the statutory framework of partnerships, defines a partnership as two or more people carrying on as co-owners of a business for profit. This should all be in your PowerPoints, hopefully, not hearing that for the first time. Unless they are otherwise formed as another business form. What is notable about that RUPA definition is note that that is all dependent, the beauty is in the eye of the beholder there, okay? If two people are perceived as two people carrying on as co-owners of a business for profit, they are deemed a partnership. They can say, oh, well, we're a corporation. No, we're an LLC. You know, we wrote the words corporation or LLC on the side of our van. Unless they are actually statutorily established as a corporation or as an LLC, guess what they are? A partnership. When does this happen? They let their LLC paperwork lapse. They let their corporation filings lapse. They don't pay the fee on an annual basis. Trust me, that happens a lot, especially in small businesses. It happens. And when that happens, when that LLC paperwork lapses, when the filing fee isn't paid on time, the business is essentially dissolved, administratively dissolved in the eyes of the state. That protection no longer exists, and they are then deemed a partnership, even if they don't think they are or they don't want to be. So it is truly an inadvertent business form. Flipping that same concept on its head a little bit, what kind of paperwork do you have to file in order to establish a partnership? Nothing. Exactly. Now, there are things that you can file and probably should file. We'll get into those in a second. Okay, but you don't have to file anything to establish a partnership. That is very different than all these other business forms that we'll talk about subsequent to this. Like this gentleman said earlier, one of the biggest challenges with a partnership is that partners are jointly and severally liable for the negligence, for the I'm going to use the term liabilities because I want you to understand that it is not just negligence, but it's also contractual obligations. All the liabilities of the partnership, the partners, any one partner can be jointly and severally liable for, okay? That means that in partnership A-B, if partner B is 100% negligent, they can go after partner A for all of those costs, all of those responsibilities. If partner B was the one that signed the contract on behalf of the partnership, and partner B isn't, putting in the money or doing the time or whatever, they can still go after partner A, even if the partner A didn't sign that contract. Yes?
What would be the motivation for somebody who going into a partnership who has more money to do that? Because should the other partner act in a way that causes liability, I have to severally be responsible where the other person doesn't even have to be jointly responsible.
Absolutely.
So why would I do that?
That's a good question.
Oh.
And you won't, because you've been in my class and you know better now. Right? I mean, really, I'm not trying to be trite, but that there is no good reason. There is no good reason why, and it's especially dangerous when you have one person who's significantly more financially liquid than the other. But I love lawnmowers and cars. I don't know why. Okay, they tend to show up in my examples over and over and over again. My dad used to race cars, and so I don't know. And I worked in product liability, did all these cases for GM, so cars and motorized and small equipment. I worked for Kawasaki and Yamaha, so I don't know. It just always seems to come back to lawnmowers and cars for me. But a classic example is, in its most basic, you're a retired landscaper, let's say. You have 6 or 7 big riding mowers. You're not doing anything with it, but you own it, you're retired, you're happy. This college kid down the street says, I really want to start my own landscaping business. You're like, great, okay. You use my equipment, it's still all in good shape. I don't have anything to do with this, I'm happy, I'm retired. But you give me, I'm going to take 10%, 20%. Well, it's your equipment, okay? He's the one doing the work. Y'all have this arrangement where you're getting a certain percentage of the profit. You're completely on the hook if it's a partnership, even though you're not the one that's ramming the lawnmowers over kids' arms. Honest to God truth, my cousin lost her middle finger in a lawnmower accident. I think that's when I remember she was 3 years old and I was probably about 6, so I remember it very distinctly. And maybe that's why I've actually used that as an example. And we've often joked, how does that happen? How do you only lose a middle finger? But she reached underneath the lawnmower to get a toy, and her father went over it. We joke that there's only one thing she's not able to do now as a result of her injury. So she's learned to, anyway, sorry. Okay, yes?
Is it, in your example, is the retired guy only liable because he asked for the 20 or 10%? If he would've just said, use my equipment, would he still be in a partnership?
I think that because he was acting, I think it would depend on how the court's gonna view that, what the end user, I should say, the customer were perceiving how the business was presented. Were they carrying on as did he have an ownership interest? Well, he owned the equipment and he had an arrangement, where he was getting a certain percentage of the profit. Is that perceived as co-owners of a business for profit?
So if he had basically gave him the equipment and said, here's a loan and you're gonna pay me back, but you're not taking an interest in the business.
Yeah, because then you don't have a profit interest, right?
So without the profit interest, you're not a partner.
I would say not.
Okay.
Because then you're really nothing more than a bank,
Right.
honestly.
So, a family member loans me $20,000 to start my business. They shouldn't be liable for the business unless they expect some return.
Right, because they're not in a profit position.
Right.
Theoretically, their loan with you is, then it gets gray because it's kind of like, well, can you pay back the loan if you didn't have a profitable interest? And that's where these things get ugly.
Right.
And get
So
and
whose
get
perception is it then?
I
When
would-
you can prove in court?
The person who is affected
Okay.
by the liability would be
Mhm.
my guess. So, and it is basically, it's how it's perceived by others, not necessarily what you intend or didn't intend. Okay. partners owe each other a fiduciary duty. Fiduciary duties are these duties and responsibilities that business owners owe to each other, and they will flow through all of these different business forms. I talk about them a lot now in partnerships, but we'll see this concept arise over and over and over. Fiduciary duty of care and fiduciary duty of loyalty are two examples of fiduciary duties that partners owe to each other. What is a fiduciary duty of care? That basically means that there is a fiduciary responsibility that partners have to each other to engage in sound business practices, using best practices, making good business decisions. Not coming to work drunk, okay? Putting in a reasonable amount of time towards making the business work. Again, sound business management, sound business practices. What it doesn't mean is definitely running a profitable business, okay? The goal should be a profitable business. The action should be taken, should be designed to create a profitable business. But whether profit exists or doesn't exist at the end of the day is not in and of itself a definition of whether the duty of care was met. Now, as I'm saying all this, can you just imagine the litigation that arises out of this? Well, had you made a different business decision, had you followed a different business practice, had you acted and conducted yourself in a different way, we would have a profitable business. So say the business owners feuding with each other in a partnership dispute, right? Okay. This is why lawyers get paid a lot of money to negotiate, kind of through some of these things. But that's the conflict, the concept of the fiduciary duty of care. Fiduciary duty of loyalty is another duty that partners owe to each other. And what does that mean? Basically, what you think it means. Partners have a duty to be loyal to each other and to not engage in competing business interests. Okay, an example that I might use, again, you know me, we're in a car dealership, okay? Two individuals get together and let's say, one of them is significantly more liquid than the other, to establish a car dealership selling, let's just say, Toyotas. And let's say one has great franchise expertise, one has great marketing expertise, the other has great sales expertise, so they're kind of joining forces together to start this business. Can one of the business owners, and let's say they started here in Gainesville, can one of the business owners go and open up a dealership in Waldo? Does that violate the fiduciary duty of loyalty? I'd say yes, because I think that a dealership in Waldo is geographically close enough to Gainesville that they could be deemed a competitor. Okay, and that would be violating that duty of loyalty to not be engaging in competing business interests. What if they go open up one in Atlanta? I don't know that anybody is going to drive to Atlanta to, buy a Toyota or not buy a Toyota from a Gainesville Toyota dealership. Okay? But again, you know what? It depends on the product that we're talking about. What if we're talking about a very, very narrowly tailored, complex piece of software that only a few people know how to make? Well, then it might not make a difference if you've got an office here or in Atlanta or in Seattle. Okay, it could be competing. So geography is not the only determining factor. It really depends on what type of market, what type of product, what type of expertise that we're talking about. So it's again, it's going to be very case by case specific example or situations to really determine what might be a violation of a duty of loyalty. Okay, any questions about those fiduciary duties of care, fiduciary duties of loyalty? All right, so let's talk briefly about the type of documents that can be filed with the state in a partnership. Because again, remember, do any have to be? No, none have to be. But there are certain documents that can be filed if you are going to completely reject my advice and still go ahead and file and create a partnership anyway. All right, what might one of those be? One of those is, and this is defined in RUPA, is a statement of partnership authority. And what that is a document that can be filed with the state that says partner A or partner B or partner C is the one who has authority on behalf of the partnership to act, to sign leases, to sign rental agreements, to do purchasing, what have you. What that does is that kind of creates a little bit of internal protections about amongst the partners about who has the authority to act on behalf of a partnership. Very often, again, used to be to define the authority of partners who have the ability to transfer real property. Again, not required though. A partnership agreement is another document that often exists, hopefully exists in the context of a partnership. And a partnership agreement is one where the partners spell out the different responsibilities that each partner will have in the partnership. Probably spells out profit sharing, so spells out responsibilities, managerial responsibilities, financial responsibility. I mean, the list could be lengthy of all different kinds of responsibilities and duties and things that could be defined in a partnership agreement. What a partnership agreement cannot do, though, and this is important, cannot waive away those duties of good faith and care and loyalty. Okay? Those fiduciary duties exist, cannot be contractually written off. Because if you think about it, how easy would that be to do? One partner has a lot of, influence and money and financial backing to say, okay, well, we're going to enter a partnership agreement. You agree that I don't have any fiduciary duties of care. I don't have any fiduciary duties of loyalty. I don't have any fiduciary duties towards you. They cannot be waived away like that. Now, what they could do, and I think this would pass muster if it was done appropriately, is define, for example, the parameters of the loyalty. Okay? I am a car franchisee. I'm going to open up other car dealerships. If I open up other car dealerships, this will not be a violation of my duty of loyalty. As long as I do it more than 60 miles away, or something like that. Again, it can be a very case-by-case specific type of situation, depending upon the product, what's being sold, the nature of the business, that type of thing. But those are just some examples of things that might be in a partnership agreement. Again, partnership agreement is not required, but certainly recommended. All right. Last thing that a partnership does, I'm going to say partnership does have to file, not necessarily to exist, but just if they don't want to die at the hands of the IRS, okay, is obviously is a tax return. Okay? Again, it's not required to exist. It doesn't create, it's not a document of formation, but partners in a partnership do indeed need to file an informational tax return with the IRS. That is one benefit, one of the few benefits that I can think of other than ease of formation of a partnership, is that partners are taxed at their individual rate. Okay? Partnerships have what is known as pass-through taxation. The entity itself is not taxed. When we start comparing corporations, we'll understand why more. That's a pretty positive thing. But partners in a partnership get their respective proceeds from the business, and they're taxed at their own individual rate. So partner A, that is a multimillionaire, is going to get taxed at 39.6%, okay, on whatever he or she is bringing in from the partnership, and partner B, who is of less means, is probably going to be taxed at a significantly lower rate. Okay. The entity itself, though, is not taxed. Any questions on partnerships before we move on to alternative business forms? Everybody got this? I can erase this? Okay. All right, so let us talk about an alternative business form. Specifically, I'm going to do something that's going to look like a formula to you. I feel like I'm an algebra teacher. And the reason why I went to law school is because I'm bad at math. Okay. If there's anything that I would encourage you to memorize, it's my little formula here. Let me break this down for you. We just talked about a partnership, right? That's my key here. is a partnership. We also talked about a lot of the problems with the partnership, why it's not